what's happening today. Every year in the U.S. there's over 150,000 new patents being awarded. This is a large number. There are 450,000 applications being processed by the Patent Office this year. Most people who are in companies that are submitting patent applications expect to get that patent at least half the time. There's a lot that won't probably come out of the Patent Office, but they're adding thousands of patent examiners to the USPTO every year just to handle this amount of patents. And when you read the annual statistics, you read that IBM has the most patents. They get over 3,000 a year. They're pursuing it heavily, and a few years ago they made $2 million on just licensing their IP portfolio. When you read the next 5 people, you notice that they're all foreign companies. Most often Japanese, Korean, and then HP is in the top 10 and some of the others. But definitely international companies for which most of you might be thinking of going are heavy into patents in the US and their own countries. Just to give you a little bit of insight, just last week the latest patent issued was somewhere about 7,500,000 and 503,000. That was the actual number of the patent in the sequence of all patents that have been issued. So it's quite a few patents. Well, when you realize up until 1836, they didn't even number patents. They just titled them. So starting in 1836, they actually put a number on it. It's been going through for the years, but fully at this time, over a third of the patents that were ever awarded are still applicable, still alive, still in the system as valid patents. That means a lot of patents going on in the last 20 years because the patent laws are 20 years from the date of filing is when a patent is valid until. It used to be 17 years from the date it was awarded, but now it's basically 20 years from filing. Right? I'm pointing to the one IP attorney that I know some. There is a patent reform bill that has been submitted again to Congress just in the past 2 weeks. There are a lot of changes being proposed. This thing has been proposed, every year for the past 5 years, at least. It hasn't got through. People are debating it constantly. They're trying to change the number of claims you can put in it, the length of the claims, how many continuations you can get on a specific patent. A lot of the administrative burden they're trying to eliminate so patents will go through this system faster so there won't be that backlog and they won't have to hire thousands of patent examiners every year. I don't know when it's going to break. I don't know how it's going to work, whether the patent reform bill will actually go through, but it will change some of the things going on. Now, it doesn't change it the same for everybody. Drug companies have been one of the companies that are fighting it because they submit patents that have a lot of claims, and every nuance on a molecule they'll claim as a different claim in a patent. So when you have a drug company out there looking at small molecule drugs or new therapeutics or something like that, they'll have a huge number of patent claims. 200 is not atypical, and it might be an inch thick as a patent application. Well, most patent examiners are given only a few hours to determine whether a patent is valid or not. A few conversations with the with the inventors, and it gets kicked back, and it just hurts their statistics, and they're paid on a statistical how many patents they get through, how many actions they take, and so forth. That's how they're incentivized. It's a very difficult situation. There's also some recent court rulings, and I'll go into them a little bit later, as to some very specific things about business method patents, where it's a lot of the things in financial instruments, some of the banking industry, some of the specific patents that have been awarded that really have a questionable technology base. In Europe, software patents do not get awarded. In the US, some software will do. It really has to be worked with your patent attorney to define what you created that is non-obvious, that is truly invented. Today's business climate, not so good. There's a lot of patent. That's an understatement, I realize, but it's difficult. Trying to get money for anything right now is very difficult, especially when you're offering intellectual property to a company who didn't either know they were stepping on it, so needed a license to it, or thought that was a way to go around what they've been doing internally as far as a product development, a technology development, a platform development. So you're asking them to spend money they didn't have in their budgets. It's very difficult. Now, I personally think that a lot of this is an overreaction, and it's because everybody is reading the newspapers. Well, no one reads the newspapers. No, everybody's watching the TV, internet, surfing to see what's going on. They're finding out that it's very difficult to break cash away from companies. They're concerned. But there are opportunistic buyers out there who will pick up IP, and they are shopping for it. And they're called bottom feeders, and they're trying to get some low valuations for it, but they are sucking out of the market intellectual property because it's the last thing people are owning in their small company. And if they are trying to get cash to survive, they are willing to sell off some of the things they might not be using today. They're taking long. In fact, I was doing 2 negotiations today for 2 very different technologies. They both have been in process for over a year. It's a very lengthy process to sell technology in this market. Things are happening, people will do it, but it is price sensitive and it will take longer than you anticipate. Recent court rulings, 2 of them specifically. Bilski is the one about business methods. This is the one that is requiring a certain usage of technology to validate that this is really a new technology. It is using appropriately new, non-obvious things, and it is justifiably getting it. KSR is one that came through a little while ago, and it's on the obviousness, which is one of the requirements we have in U.S. patent law, is that it cannot be an obvious improvement. It has to be non-obvious to somebody skilled in the art. This is one of those conundrums. If you're skilled in the art, then once somebody tells it to you, it is obvious. How do you hit that mark and say, no, this was non-obvious. I put together things that have never been put together before. Used it in this situation that's never been done here before. It's difficult. And this is where I go back to finding good IP attorneys that can do right applications and can defend what you're trying to get to the patent office in the proper way. A few years ago, the patent office was deluged with so many applications to get up to this 430,000 range that bad patents were getting out to the marketplace. And a lot of them were being thrown back to the patent office for re-examination and saying, is this a valid patent? And court cases were being thrown out, and that's why some of these things are trying to tighten up the system. It's a little too early to say exactly what their outcome is going to be, but to me, it looks like they're trying to do some corrections. I think it'll improve the whole situation.